before we start, I just wanted to go over a couple disclaimers. We are providing general guidance, and nothing should be used for any specific situation today. Any specific situation, any case-specific questions that you have should be addressed by a case-by-case analysis with an attorney. If you need assistance on a specific case, please contact us directly so that we can properly advise on the issue. After our presentation, we will have a short Q&A that will be taking place via the messaging function of the webinar. You'll see that in the platform. There's a section that says questions. I kindly request that you select that you send your question just to staff. And finally, if you do submit a question, please keep it general. We cannot fully ensure confidentiality if you submit a question. Anything you send to us in the form of a question could potentially be viewed by other parties. Questions will not be able to be spoken through the line, and that's really just because we're trying to protect your confidentiality today as well. So again, my name is Rojine Mozafarimer. I'm an associate attorney here at MPLG, and welcome to Corporate Immigration Best Practices. Okay. So first, we're really going to be talking about H-1Bs today, and so many of you already know this process, but we thought we'd be going over basically the basics as well as many changes that we're seeing under the new administration. So first, we wanted to talk about how we initiate a case. So as most of you know, whenever we initiate the case, we have listed in our initiation worksheet several items. We've listed four of the most important here: the job title, the duties, the wages, and the work site. In the H-1B world, the job title really should be conforming to what's called that Specialty Occupation Code, or the SOC code. And so what is a specialty occupation? Basically, the way that it's defined is it's a position that is so highly specialized and complex that it requires at minimum a bachelor's degree in a related field. And related here is what's key. As most of you know, we do make a real concerted effort to review a candidate's qualifications to ensure that they have the right degree for the position. So sometimes you'll see that you'll have a job title, and we'll push back a little bit because we're trying to figure out how to place this person within what that specialty occupation code. The USCIS, more and more, especially recently, has been really cracking down on making sure that there's this alignment. So keep that in mind when you're, when you see that we are questioning the job title. We're really just trying to make sure there's alignment with the specialty occupation. The duties should also match the specialty occupation rule. The USCIS, they use the Occupational Outlook Handbook, which is released by the Department of Labor, as the controlling guide on the nature of these SOC codes. And please note that all roles are not in the OOH. You will note, for example, there is that classification, computer occupations all other, where there'll be like network engineer in there, for example. That is not listed on the OOH. So what's the significance of that? The OOH will list how to become, for example, a software developer, and it lists that there has to be. Usually you have a bachelor's degree in a related field. If there isn't an OOH page for a certain role, for example, a network engineer, there is no controlling authority that the USCIS can look to or that basically determines what that bachelor degree is. And so we try our best to guide you to have those SOC codes that have that raise the least red flags, that that really do show that you do require at least a bachelor's degree for that role. There are times when you just can't fit them into a role that's listed on the OOH, and that's okay. We work and do a case-by-case analysis to make sure that the person has the right qualifications, the job duties match that role, and in the event of a request for evidence notice or an RFE, we always work with an expert to provide an opinion to basically prove that that job is in fact a specialty occupation in that it requires a bachelor's degree in a related field. The wages, so we'll talk about that in the next slide. There have been some changes, some recent developments with that, but that's also important. And then finally, the work site. We also request the work site. That's important as well. That's what's listed on the LCA. The beneficiary needs to be at that location pursuant to the H-1B petition that is filed. What's also important here is the internal org chart. So what happens is you have a number of H-1Bs, and then you have non-H-1B employees as well, of course. So your wages must be consistent across the board, regardless of immigration status, across all job titles. So if you have a software developer who is in H-1B status, and then you have a software developer who is a U.S. citizen, they should have comparable wage levels. They should be paid the same or within the same hierarchy as your company policy provides. Titles must also need to be consistent. There is always a one-off position that's unique and you only have one person serving that role, and we understand. But if you do have a bunch of computer systems analysts or software developers or construction managers, your title should be consistent across the board or through your hierarchy. So finally, we do provide organization audit services. We do know that sometimes, things do fall through the cracks. So if you are interested, we do help in terms of identifying any issues that may arise in such situations. So skipping forward, DOL wage levels. So the DOL has standing guidance on how wage levels are to be determined for roles. What seems to be an arbitrary process actually requires a calculation that takes into account several things, which includes the education level, the experience level, skill requirements, and managerial tasks, which are evaluated against standard calculations of these items for each SOC code. So the reason why we're focusing on this a bit today is because this is actually one of the recent developments under the new administration. We are seeing a nationwide attack on level 1 positions right now, and we're seeing that in the form of a request for evidence notice. And so what the USCIS is doing is they're looking at level 1 positions, they're looking at the wage, and they're looking at the job description, and they're wondering if those roles are in fact an entry-level position. And so here on the slide, you'll see that we have definitions of what level 1, 2, 3, and 4 mean. Level 1 is really a beginning level role, and so that's for someone who has a basic understanding of the occupation. These are people straight out of school, don't have experience, really just have the bachelor's degree, the theoretical understanding. And in serving that level 1 role, they're really becoming familiarized with the employer's methods, practices, and programs. They might do some more complex work, but it's always under the supervision of a higher supervisor. And so what I wanted to also walk through today is basically how these level calculations should be done. So what seems to be pretty arbitrary, where you would provide in your worksheet a salary, and we would say, oh, that's a level 1 or level 2. Because we're seeing this attack, we really want to provide an overview of how these levels actually should be determined. And so there is a guidance by the Department of Labor that basically has a step-by-step guidance on how to get to which level you need to be. They first, you start at level wage 1, and then they ask how much experience your company requires for that role. If it's entry level, it's 0. If it's anything more than that, then you are looking at something that might actually elevate you to a higher level. Then they'll ask you about education. If the OOH says that a bachelor's degree is the regular requirement, then you require a bachelor's degree, then it would still be at 0, and so you'd still be at a level 1 wage. However, if the role in the OOH requires a bachelor's degree, but your company requires a master's degree, then actually you would add a 1 there, so it would be a level 2 wage because your company's requiring a higher level of education than what is standard for the industry. Another consideration is special skills, and so if there are any special skills, knowledge, activities, licenses, or requirements that are more than what's standard for the role, then that would also elevate to a level 2 or level 3, depending on the other factors. So if there is no requirement for special skills, then that would also be a 0. You'd still be at a level 1. And then finally, supervisory duties. If you are a software developer and you have no supervisory duties, well, that's great because the OOH does not state that supervisory duties are standard for that role. For a computer information systems manager, however, there are supervisory duties, but this would still be a 0 because that's standard for the industry. So after this webinar, we are happy to share this chart with you on how to calculate these levels, but we would like to indicate, that we have always steered our clients away from starting at a level 1 unless your position really just requires a bachelor's degree and no experience, and it's really an entry-level position. And we are happy to do, as we do, a case-by-case analysis for each role. We are seeing that the USCIS is really looking at this now, so we really recommend that, you speak to us as you move forward with your H-1Bs in calculating those wage levels and making sure that those job descriptions and those roles really match what those levels should be. And, of course, our favorite, the public access file. So I've received a number of questions over the last month about the public access file. And so every company is required to create a single file which evidences the compliance of the company with H-1B laws that is readily available to the public or the Department of Labor. And so it should be really created within the first day of filing that labor condition application, the LCA. And it should be kept on site in a separate file from the personnel record. So these files should not be with your HR record for that employee. You will see on the platform that we have several handouts uploaded. We have also uploaded what you should already have as we send it with our initiation emails, but for your reference, we have templates for each of the documents that should go into that public access file. These are the most important ones. There should be a copy of the signed and dated certified LCA with, and there's a template for that and the statement that needs to go in there. The rate of pay for the H-1B worker, the actual wage memorandum, which basically attests that you are paying the actual wage based upon the level of education, experience, knowledge, etc. There is a prevailing wage notice, the prevailing wage determination. It states, when we're looking at those levels and we're looking at what the levels are for a particular metropolitan statistical area, we show those wage levels. You should have a printout in there of the wage levels for the at the time that the LCA was filed. There is a notification confirmation of the LCA. So this is actually a statement that the company has attested that this LCA was posted in 2 places, how long it was posted, and where they were posted. And finally, a copy of your benefits summary, so what benefits the employee would be afforded as an employee. We are happy to go over your public access files. We do provide audits. I do strongly recommend that your public access files be in order. We'll be speaking soon about other trends regarding site visits, but this is one of the most critical aspects of company compliance in the H-1B realm. And one additional item, so what happens when you do get a site visit? Any person in the public can come to your company and request to view your public access files. And they should be up to date and they should be readily available. Finally, the employee needs to be working in the role pursuant to that public access file. Finally, when you do have the public access file, if someone leaves, you should be holding on to those public access files, even if the employee has left, for at least 1 year. If you have any specific questions about your public access files, how long to hold on to them, old ones, new ones, please do not hesitate to reach out to us. So next, another very popular item in the H-1B world is amendments. So pursuant to a case in 2015, the matter of Simeo Solutions, an H-1B amendment petition is required when an H-1B employee is changing his or her place of employment to a geographical area requiring a corresponding LCA to be certified to the USCIS or due to a material change in the terms and conditions of the employment. So what does that mean? An amendment needs to be filed anytime there is a material change to the current H-1B holder's employment. That includes if there's a job title change, we would need to do an analysis, make sure whether they need to have, if it's a material change, sometimes it would go from software developer to senior software developer. That would probably require an amendment. If there's a change in job duties, then that would require an amendment. If it's a change in location, so let's say you have an office here and you have an office in North Dakota, and the H-1B petition was filed for California, but they're moving to North Dakota, we need to file an amendment. And then for consulting companies who have end client placements, if you have a person placed whether in one location and their end client changes, but it's next door, you still do need to file an amendment because the end client has changed. That is a material change to the conditions of the employment pursuant to the existing LCA. If for any of the above changes take place, these amendments need to be filed before the H-1B holder moves. So if you ever see that there is a change that's going to be taking place, please contact us so we can do a thorough analysis. But these H-1B petition amendments need to be filed before the employee can move or change roles or change duties. One other example, just to kind of shed light on the amendment issue. So let's say someone is working for your office in Newark, California, and you have a second office in Fremont, California. Would you need to file an amendment there? Well, because they're in the same metropolitan statistical area, we would have to do that analysis, but we know that it's within that area. Technically, just the old LCA would need to be posted at the new location, so long as nothing else about that employment has changed. Now, what about if the person is working in Newark, California, and is moving to San Jose, California? Well, there an amendment would have to be filed because even though to us it's fairly close, that is a different metropolitan statistical area. So an amendment would need to be filed. If someone is working as a software developer and is then being promoted to a director of engineering, for example, an amendment needs to be filed. And finally, with amendments, sometimes amendments can be filed without an extension. That is a case-by-case decision that is made by the company. And you can also file amendments and request for extensions as well. So you will, as a company, you will always have situations where, an H-1B employee might be terminated. So the company does have compliance obligations in the event of a layoff or termination. So the employer technically is responsible for offering to pay for the return ticket home for the terminated H-1B employee. So what does that mean? Let's say you lay someone off and they don't have another job lined up. You, as the company, as the firing company, actually do have an obligation to pay for the return ticket home. This could be in a lump sum. This could be the company arranging for the ticket and purchasing it on their behalf to have them go home. As of January 2017, employees do now fall into what's called a 60-day grace period for their H-1B status if they are terminated. Now, there are some limitations to this. So what does that 60-day grace period entail? Let's say you are laying someone off and their H-1B validity period is only valid through October 15th, 2017, so a little less than a month from now. The employee would only have a grace period until the expiration of their current H-1B. Thereafter, they would be out of status. So their 60-day grace period is cut short. It's truncated by the H-1B validity dates. Now, in another situation, let's say that someone is laid off and their H-1B doesn't expire until October 2019. Assuming they have not fallen within a grace period during the current validity period of the H, they will have up to 60 days in a grace period for their H-1B status. Now, what does that mean? They can basically, it's allowing H-1B employees to situate themselves to find another job if they can, or affords them more time to arrange for themselves to go back home. If you do have any situations like this, please reach out to us so we can provide more detailed analysis on the issue. Finally, employers also have obligations with regarding to that existing H-1B petition once that employee is fired. So employers should be withdrawing the LCAs within 10 days. We can do that for you. You should also be notifying the USCIS to withdraw that H-1B within 10 days. And we do that for you as well. You just need to let us know. And finally, as mentioned before with the public access file, you must maintain the LCA for at least 1 year after the date of termination. And please, we request that anytime you do have any sort of termination to let us know so we can close out our files as well. As it is CAP's, we're nearing hopefully the end of CAP adjudication season. You do have some approvals out there, or approvals coming, where people will be going for consular processing. You also have non-CAP cases where people need to go for stamping to get their H-1B visa. And so you'll see on the platform that as one of our handouts, we do have our consular processing checklist. Please take a look at it. If you have any specific questions, please reach out after the webinar. But it is really important that your H-1B employees have the right documents when they go for the appointment. They should have their I-797 approval notice in hand. They should have a copy of the petition in hand. And that includes all of their forms and your corporate documents. Now, because your corporate documents that we submit with these petitions do have sensitive financial information, we strongly advise that you redact on page 5 of the I-129 your income information and seal your financial documents before handing the petition to the employee. The beneficiary should also have a valid passport with at least 6 months of validity in the passport. And then finally, we are seeing that across the board that sometimes there's a little bit of a delay in an initial H-1B, someone going for stamping. So what does that mean? Let's say you had a CAP case filed in 2016, and technically when you're filing these cases, you need to have a position available on October 1st so the beginning of the fiscal year of that same year. And then what we're seeing is people are going for stamping 4, 5, 6, 7 months after the start date on that petition. Visa appointments should be taking closer to the start of the approval period, because what the officer can do is question whether that position was actually available on October 1st as of the start date that was indicated on the petition. And what we're seeing is a newer trend that most of you know about is the uptick in administrative processing through the issuance of what's called a 221G referral. And so what does that mean? An H-1B applicant goes to a consular appointment. They are applying for a visa for a position that they should have started maybe 6 months ago, 8 months ago. The officer is not satisfied, so they issue a notice saying that it's going for additional processing, and they might be asking for more documentation. They might request an employer verification letter that attests that the job was actually available, that it's still available. They might want updated corporate documents. Each 221G is different, and it's discretionary, but we are seeing a strong uptick in this. So we would like to keep your H-1B program as seamless and efficient as possible, so we strongly advise that you have your CAP H-1B approval cases go for stamping as close as possible to the approval date. So if you already have an approval, you have employees with approvals, please instruct them to go for stamping now. If you do not have approvals yet and they're still in processing, then upon the approval, if they need to go for consular processing, they should schedule themselves for appointments shortly thereafter. And if you have any issues, please contact us directly with your specific questions. And then finally, we can assist with interview prep. We do know that beneficiaries, it is a nerve-wracking process to go to these things, so we would be very happy to set up interview prep calls with you and with the employee. We would need a company representative on the line for the interview prep. So this circles back to our LCA initiation worksheet a little bit, but we do try our best to conduct what's called a pre-hire analysis. So this is not necessarily related to your CAP cases, but this is for your change of employers. And what happens is sometimes you onboard someone, you've tried to screen them as best as possible, but you might not know how much time they have available in H-1B status. They may have held L1 status, which also counts against their H-1B time. And so they might not have an approved I-140, which allows them to extend sort of indefinitely until their date is current to apply for a green card. They might have qualification issues that might require additional expert opinions or education evaluations, status restrictions, violations, dependents. All of these are really nuanced factors that we try to catch right at the beginning. And so we strongly urge you that for any case, especially those change of employers, please complete that initiation worksheet. Part of it also requires us to collect those approval notices and documents from the beneficiary. So sometimes you'll see, we won't get documents from the beneficiary until 1 or 2 weeks after we've initiated the case, and then we're only then made aware of, oh, this person might only have 2 years left in H-1B status and they don't have a PERM or an I-140 on file. And so we try our best to communicate that with you. We also, as most of you know, I do handle the H-1B matters here, and Amir Sheikh, he handles the immigrant matters, so the PERM I-140 process here. So we try to communicate as much as we can internally and with you to make sure that we're all in line so your program goes forward seamlessly. These considerations aren't just for the beneficiary, but also you as a company. Sometimes it is important to know whether you're able to keep an employee for more than 2 years or not because of these restrictions. So if you do have any specific issues like that, please reach out to us directly. And with that, I'm just going to switch it over to Amir, who does run our PERM program, who's going to basically discuss layoffs and the impact that has on the PERM process.
Thank you, Rojeen. Once again, my name is Amir Sheikh. I handle largely the green card process, especially in EB2 and EB3 categories at Matthews and Patibota Law Group. And you've heard a lot about the H-1B in this webinar, and I want to sort of stay within that realm, but take a moment for you to look at that last slide that Rojeen presented, which was considerations at the time of hiring about how much time they have left on H-1B, so that you potentially have enough time to do the PERM process and qualify them on EB2 or EB3 typically. So that is something that occurs at the time of that one person's hiring. Now, the other thing that you have to keep in mind that impacts the PERM process are layoffs. Layoffs not just of your H-1Bs, but also of your entire workforce. So the definition of layoff under the PERM regulation is that it's any involuntary separation of one or more employees without cause or prejudice, which means that if you lay somebody off for cause, these at-will employees who are laid off for cause, then the layoff analysis is not triggered. And if there is deemed to be a layoff, then the limitation is that a layoff within 6 months of filing a PERM application, in those particular cases, you will have to notify any qualified U.S. workers that were laid off. So if the layoffs were just of H-1Bs, then the layoff analysis is not triggered. If the layoffs were of U.S. workers, then the layoff analysis is triggered. Finally, when you're thinking about layoffs and how to report and whom to report, do not be thinking of just H-1Bs, because that's a different concept, and that relates to how you withdraw the H-1Bs, LCA and things like that. What we're focusing on right now is any layoffs across the organization impact your ability to file green cards. So when any employee is laid off, you should continue telling us that layoff has occurred and X, Y, and Z U.S. worker was laid off, so that we can evaluate their job duties, and whether they fit in the area where you may be running other PERMs. And then if that's the case, we'll go further from there.
Thanks, Amir. Okay, so that was a lot of technical information, a little bit dry. If you please review those slides and those handouts related to it. If you have any questions at all, reach out to us. I wanted to get into the new developments under the new administration, which I think impacts quite a number of people. So as of yesterday, premium processing is back for H-1B cap cases. So April 2017 filings only. Premium processing is not back for amendments and extension filings yet. So what does that mean for you? Basically, with premium processing back, we would need to do a case-by-case analysis for all pending cases to determine whether upgrading to premium is the next best step. While it might sound like, you know, we should upgrade immediately for all cases, we want to make sure that you have all the right documents in line and supporting documents in line before we just upgrade all the cases. There have been many changes in visa adjudications under the executive order from April 2017, Buy American, Hire Americans. So I wanted to just go over a few of those changes. So there have been changes in the Foreign Affairs Manual. So what's the Foreign Affairs Manual? The Foreign Affairs Manual is what consular officers use as the controlling guide to adjudicate visas, processing, consular processing at consulates across the world. As of August 2017, and then as of September 1st, the Foreign Affairs Manual has been changed in several ways. It's empowering officers to apply more rigorous standards and higher levels of scrutiny at visa interviews. We've anecdotally seen this happen, and you might have had one-on-one conversations with any one of us attorneys in the office about that for your specific cases. But it seems that those that extreme vetting, that additional scrutiny, has now been formalized in the Foreign Affairs Manual. The guidelines, though, are still a bit ambiguous, and we're vigilantly monitoring how the implementation process kind of unfolds with these new changes. So it is official that they have formalized just additional scrutiny for each visa classification. I'm just going to jump down because it relates to it, site visit. So prior to this directive, the USCIS has always conducted random administrative site visits since 2009 to ensure H-1B compliance. And that's still going on, and you might have experienced that where an officer or a contractor has come and just asked several routine questions about, you know, seeing your public access files, seeing your employee and asking about their role, and, you know, it was just a random selection audit, and it's done. But now the USCIS intends to conduct what's called targeted site visits, and this is stemming from that April 2017 executive order. And they're focusing on cases where the USCIS cannot validate the employer's basic business information through commercially available data. So what's commercially available data? The USCIS uses what's called Dun & Bradstreet to check your company's location and information. So you might have heard from us before about that, but we strongly advise that you check your Dun & Bradstreet company information page and make sure that your address and name or anything is completely updated. You might have changed company names, you might have changed locations, and those might not be updated on Dun & Bradstreet. I will note that it also takes a while for Dun & Bradstreet to update those profiles, so please keep a record of when you request a change, whether it's through emails or confirmation or screenshots, and then just monitor that that change is made. They're also targeting H-1B dependent employers. And then finally, employers petitioning for H-1B workers who work off-site at another company or organization's location. These are also known as consulting companies. So these are the three big groups that they are focusing on. So this is in tandem to those random administrative site visits. So that's also stemming from that executive order. And then finally, stemming from that, just jumping down, the USCIS is now requiring interviews for all employment-based green card applicants. So if you have, so this is across the board. They've also announced that this might be expanded to many other categories. So as of October 1st, if you have employees who have approved I-140s, were able to apply for adjustment, and those adjustments are pending, they will now be required to go to an interview. Now, recently, the partner of our firm, Kalpana Petibotla, and I, we went to a USCIS engagement where we had the chance to speak with the field office director at the San Jose office, and we asked about this and what kind of is the focus of these interviews, and he assured us it would be basically he didn't guarantee it, but just basically said that their goal is to have these interviews be just like the family-based green card interviews, where they only look into the adjustment application, that I-485 application. As some of you may know, there was always the, I guess, the chance that an employment-based green card applicant would be interviewed. Usually they would only be called into an interview if there was maybe a question about their I-140 or something in their employment history. That is not the case, we hope, for all these now required interviews. They still might be asked those questions if there is an issue like that. But for the most part, we have been told that they expect that these interviews are only focusing on the adjustment application part of the process. And just to add something to that, as of January 2017, there is this new form that's also required. You might have people who had a PERM filed with another company, they've switched over to your company, they have an I-140, they're waiting for their green card. They've changed roles, and you might have heard us talk about same or similar occupation when you're doing the PERM and the I-140 process. There is now a new form that's called the I-485J that is now required to be completed, and we are, well equipped and happy to assist with going over that process should a request for evidence or anything like that come forward in that process. So jumping over to advanced parole, you might have some people who are in adjustment pending status, or they're operating on some other status other than H-1B, or they're filing for adjustment and they're in H-1B status. They file for what's called advanced parole on Form I-131, which allows them to travel abroad while that green card application is pending. They have updated the instructions on the I-131 and announced that, contrary to policy for the last few years, that they will consider a pending application abandoned if an applicant travels while that I-131 is pending. Now, this is completely contrary to what the policy that was enforced up till about the last month. We used to be able to file the I-485, the I-131, the I-765, and then, if they had an H-1B, an employee could just travel while those applications were pending. For now, the I-131 will be considered abandoned if they travel while it's pending. So just another obstacle and kind of limitation for your employees in terms of travel and considerations for that. This is one of the biggest things that I've seen on the H-1B side without premium processing over the last 6 months, and that's driver's license expiration dates. I'm sure that you've had employees who've come and said, my driver's license is expiring and the DMV will not accept my receipt notice as evidence of status. And Unfortunately, the DMV operates independently from USCIS, and this is actually an issue that was also brought up at that USCIS engagement that our office attended. And while the employee is allowed to work pursuant to a receipt notice, they are unable to get a driver's license extension without the approval notice. The only option that your employees have until those H-1Bs are approved is to apply for what's called an AB60 license. It is basically the ability to drive without conferring immigration status, but it cannot be used actually as a legal ID. That's the only way to basically circumvent this issue with the driver's license until that H-1B is approved. So for now, that's what we have. I would like to open it up for questions. If you take a look at your our platform on the GoToWebinar, you'll see that there's a question option here. If you have any questions, please insert your question here and just send it directly to staff, and we'll be reading out those questions as they come in.
So as the questions come in, I just wanted to clarify or a couple of things with you, Rojin. Yeah. One was related to visa stamping, and you explained how when people are at the consulate, what kind of activity and documentation they need, and we're willing to prep that. How about when they are re-entering the United States? What kind of protocols should we be following? Oh,
that's a really good question, extremely important. So they should have a passport with at least 6 months validity. They will in there. They should have a valid H-1B or visa stamp in there. They should have a copy of their H-1B, or they should have their H-1B approval notice in hand as well. Those are the 3 most important things. And once they enter, they do generate, as most of you know, that arrival departure record on Form I-94, which is electronically generated on the CBP website. We strongly, strongly recommend and advise that you let your employees know that every time they re-enter, that they immediately go on the I-94 website and they pull up their I-94 record and inspect it for any errors, to send you guys a copy, and then please forward it to us so we can take a look and also update our records. So why is that important? The I-94 is what's controlling for the time that these employees can spend in the U.S. So let's say that they have a passport that only had 6 months validity. Sometimes what we see is officers will truncate a 3-year H-1B stay to only 6 months. And we will then have to advise whether the employee is able to just exit and re-enter with a new passport, or whether an extension petition needs to be filed. There are also issues where there's mistakes made at the border, and so what we do is either advise the employee to go to deferred inspection, which is in San Francisco, to correct the I-94, and we do also offer deferred inspection services as required as well.
One of the things that I've seen sometimes is that dependents that are traveling with the beneficiary, their passports, if they're shortened, can impact the primary beneficiary's validity in the I-94. So if your child's passport was only valid for 7 months and yours is valid for 7 more years, they might use the fact that the child can only be present for 6 more months and truncate your I-94. So that's something to keep in mind with your kids.
Definitely. It looks like we do have a question about the AB60 license, and basically AB60 driver's license is correct. It's only available in California. Is there anything which is similar to this in other states? We would have to do basically a case-by-case, state-by-state analysis, but California is the most progressive in this area. And so I do not want to speak out and say other states do not have that. They might, but we do know that California does have the AB60 license, and that's available to the California residents. If you do have someone who's living in another state, we can assist in looking up to see if other states have comparable offerings.
Yeah, from what I recall, it was only a handful of states that had it, so we can generate that
Great.
number.
I have a question here about cap gap. It is September 20th, and for those of you who have cap cases pending and employees who are in cap gap, how long does the cap gap extension last? So the cap gap extension lasts through September 30th. So cap gap extends both F1 status and then, as applicable, employment authorization. After September 30th, your employee, if the H-1B cap petition is still pending, they need to stop work. But they can still remain in the U.S. until the H-1B petition is adjudicated. If the student's H-1B petition is denied or withdrawn or revoked, the student will have the standard 60-day grace period from the date of the rejection notice or the program end date, whichever is later, to prepare and depart to the U.S. So if you have any questions, you have any F1 specific questions on that, please let us know. We do know that as we're approaching, we do have many cases that are still pending. So please let us know.
There's a question about change of status at H-1B and consular processing at H-1B for CAP. If a person's picked up for and they were filed as change of status, do they have to go for stamping?
That's a really good question. So if we have filed the case as change of status, that employee needs to be physically in the U.S. on October 1st. They automatically change status for H-1B. They do not have to travel and should not travel prior. They should be in this country on October 1st because they will automatically change status to H-1B. If they travel thereafter, they will have to go for stamping because they do not have a valid H-1B stamp in their passport. But they do not need to travel for the purposes of changing status to H-1B.
So this is a good question because many times the people that are filed as change of status at CAP and then they get picked up in the lottery, they are F1 students, and they have been in the United States for many number of years on that status oftentimes, and some of them have been reluctant to go back to their home countries and get a new visa unless they really, really have to. So once they're finally picked up for the H-1B, they're here in the United States on October 1st, they're probably going to want to go back home and get a new visa stamp. And this hooks back to okay, you've got this F1 working all through the year. He or she got picked up in the lottery, and now it's October 1st, and they've officially changed status into H-1B. They might, put in a request to go home for vacation and a visa stamp. But in light of the fact what Rojin mentioned earlier, that there's 221Gs that are often being issued, and that consular processing can sometimes lead to administrative processing. You'll potentially want to game plan their departure and visa stamping a little bit. While you definitely want to give them the opportunity to get the visa stamp to go home, you also have your business considerations, and so that's a conversation that we see happening a lot. So the change of status question for F1 OPTs, I think, is connected to that consular processing element.
Yeah. I do have a question here about programmer analyst positions. Basically, can we file as computer programmers anymore? As most of you know, we did send out an alert on March 31st. The USCIS issued a memorandum that basically announced that computer programmer level 1 just is not a specialty occupation. And so that does change the nature of some companies and how they employ people and how they file. And so we've always advised to stay away from the computer programmer occupation because of the amount of pushback that we've seen over the last few years. And so we, in some ways, predicted that this would happen, especially at the level 1. We strongly recommend that you do not file in the computer programmer occupation just across the board. Do we
we still have time for a couple of more questions. And in the interim, I can raise a question that I sort of have seen come up as well with respect to some companies as you grow and you expand your program, the org chart. We're always asking for your org charts, but one of the things that often concerns me is that the organization chart is perhaps not updated yet, on a routine basis. So that's definitely something that you want to have, because if it's going out in your petitions, that means that any potential site visit, they might be using that org chart to kind of, evaluate what your company is doing, who is here doing what. And so those org charts, not only do they have to be consistent with the immigration filing, they also have to be updated. And it actually will help you see your organization a lot fuller as well for that layoff analysis that we mentioned. Is that another question?
Yeah, I think that there is another question here about, okay, so we've talked a bit about the OOH and how that's controlling, and you've heard us talk about ONETs before. So I have a question here about how is ONET used. So ONET is another source that we as attorneys use to basically figure out what's called the job zone and the special vocational preparation for these roles. So what does that mean? So this circles back to our discussion of wage levels and how the OOH does not have official pages for all specialty occupation codes. So what we do is we first go to the OOH, that's the controlling source that the USCIS references for these roles. If it's not there, we go to ONET. And in ONET, all those SOC codes do have some sort of explanation of what these roles entail. We make sure that the job duties line up. But the issue here is that it is not controlling on the USCIS. It is just a secondary reference for us. But I do want to kind of just touch really quickly on what this special vocational preparation and job zone is. So we were just talking about determining whether a position is a level 1 or a level 2. For most cases, it obviously changes with the SOC code. For example, a software developer, there is what's called a job zone 4. It's a job zone 4 position. And what does that mean? It's occupations that are similar, that require considerable preparation, which usually translates to a bachelor's degree. And then if let's say that you have someone working as a management analyst, for example, and that's the role that you're serving, that's actually a job zone 5. And so the minimum there would be a master's degree. So we take a look at ONET to make sure that, let's say you want to hire someone as a management analyst, but they only have a bachelor's degree. We want to make sure that that person qualifies for it, they meet that requirement, because it kind of describes what the industry standard is there. Okay. So I do have a question here about whether there's any additional webinars that we have recorded on the immigration process. I know that we're going to be having, I know that, we spill a lot of we throw out a lot of technical information out there. So this is our first webinar on this topic, but in the future we will have an introductory level process sort of discussion for new HRs. So if you do have a transition, which I know a lot of companies do as they grow, in positions in HR, I know that we kind of have to pass the torch to the new position, the new HR contacts. Anytime there's a change like that, please let us know. We would be happy to get on a call, meet with you, and sort of go over the basics of what an HR contact is basically responsible for, what we can do to help you. So anytime there is that sort of, passing over of the responsibilities, please do let us know. But in terms of general information about the visas, our website does have quite a number of resources about the various visa classifications and offerings. But anything specific that you might have regarding cases, we are happy to assist with case-specific questions. And for HR training, we can provide those services.
We also do have existing handouts that relate to various topics, and we can like a group of 5 or 6 of those would be very useful. There is definitely also a PERM webinar that is in the works. We wanted to sort of move from first to H-1B before conducting a PERM webinar, and that one is going to be at an introductory level because the weeds are actually quite thick in there.
Yeah, and as mentioned at the beginning of this webinar, we are planning on doing these webinars quarterly. So this is our first one of the quarter, so we will make sure to update you as the next one comes along, but we will be hosting these webinars quarterly on these questions. And then finally, as you may have seen, at least from Shayna and I on the H-1B team, Amir has his basically tracking for PERM. We are going to be sort of transitioning as a firm to doing a little bit more tracking of your employees to make your H-1B programs move a lot more efficiently, be more seamless. So what does that mean? We are in the process of putting together basically a report structure where we will be doing reports on your employees, your current employees, their status expiration dates, their passport expiration dates, their I-94 expiration dates, as well as their job titles, and just be able to provide each one of our clients a detailed summary monthly, eventually, hopefully bi-monthly, where we can kind of identify who can apply for an extension 6 months out, who needs a new passport, who might have a truncated I-94 that we need to do a deeper analysis on, that sort of thing. And then if someone's job role has changed, we can know so we can file those amendments. So you will be seeing emails from me in the coming weeks requesting an updated list of your current non-immigrant visa holder employees. That is because we want to basically make sure our records are updated, and we are going to start, we will have a whole basically overview of this process, but we're going to start requesting that your beneficiaries send to you their I-94s anytime they travel, and then we will be able to keep a record of that for you, so we can let you know if there are any issues with their record and their time here in the U.S. With the end goal that your H-1B and related programs are working efficiently, no one falls through the cracks, and just everything moves seamlessly. Okay, well, with that, if we don't have any more questions, we want to thank all of you for spending this hour with us. We have recorded this presentation. We will upload it to our website in the coming days. Please don't forget that we have uploaded those handouts to the platform. Most of you should have them, but in case you don't, there are some, there's some really good information in there, especially for your beneficiaries. And again, if you have any case-specific questions, please do not hesitate to reach out to me for H-1B or non-immigrant visa-related issues. My email is roujin, as in Nancy, @mplg.us. For anything that is PERM or I-140 related or EB1 or O1 related, please contact Amir at ameer@mplg.us. Thank you so much. We look forward to speaking with you soon.